This is the current federal tax developments for the week of September the 15th, 2025. Current federal tax developments are brought to you by your state society of CPAs. I'm Ed Zollers, and we're going to be talking this week about various developments that occurred in the area of tax. Wasn't exactly the most important week of developments, but we do have a few things happening here. I'm talking about a case where the court frowned on a tax professional's use of randomly generated Social Security numbers. This particular tax professional had been in trouble before, so we'll talk about how she got herself in deeper water. We're going to talk about a taxpayer who attempted a really interesting way of reading Section 30D. So we're going to talk about the placed in service rule for the electric vehicle credits. This is actually the old version prior to the Inflation Reduction Act, but it was an interesting try at literally reading the text of a section, and we'll talk about why that kind of fell apart. And it is an interesting discussion about what you have to be careful of when you're trying to interpret text in a statute. We'll also go to a case where the advisors were found to owe treble damages to impacted taxpayers, and these really were promoters, basically, as all practical purposes go, that maybe had a few other things going on that they hadn't quite told the taxpayer of. In any event, everything fell apart. They were basically nailed by the IRS, and so they turned around, sued the promoter, and the promoters got hit with treble damages. So we'll talk about how that came down. We're also going to have what may be one of the more interesting cases this week from a this might matter to a client standpoint if you work with any cannabis businesses, is we do finally have a case involving the Section 199 Cap A qualified business income deduction and cannabis businesses, and specifically how you compute W-2 wages, which is likely to be a very big issue for cannabis businesses that are not those who are producing the cannabis product, but are retailers. And finally, we'll talk about the trust fund recovery penalties and how, basically how you end up having to be considered a responsible person who could be liable for the trust fund taxes. And as we'll discover, we're going to look at two different parts of the question in this case. Was this person truly a responsible party? What do you have to meet to do that? And then number two, if he was a responsible party, what exactly would make his acts willful? As we'll discover, the court went for summary judgment on one of the issues and basically said, yep, what he's done, the background here, the information about him that we have, his position in the business, makes it pretty clear that his actions would be willful if he is truly a responsible party. And then we will get to whether he's a responsible party or not, which the court decided that needed to go to trial because there was a true dispute of facts. But let's go ahead on to our interesting tax preparer problem. And this was a preparer who was found in contempt of court for her due diligence failures. And this is a case of United States versus Martha Velarde. This is from the United States District Court for the Central District of California. This is case number 2:11CV01458. And this case came down, the opinion came down on September the 8th of 2025. The key issue in this case involved a taxpayer or a tax preparer who persistently didn't comply with court orders, and specifically related to the due diligence requirements when a preparer is preparing a return where a taxpayer is claiming head of household status. And what she was doing was purposefully using randomly generated Social Security numbers on the tax returns to get them to go through. Unique, I'll admit that, but apparently the court was not enamored with this particular choice of option by Martha. This case is a reminder of the consequences of failing to follow court orders. That's normal. But this is a case, too, of a taxpayer who was not shut down from performing work, but she had already been hauled in front of the court about problems with her work. And she still went ahead and, despite that, decided to take this little workaround. So, yeah, we have a little problem here with Martha's work. So Martha Velarde was a tax preparer since 1998, and she was initially sued by the government in 2011 for preparing returns with false information. A final judgment of limited injunction was issued against her in 2011. And it prohibited her from engaging in activities subject to penalties under IRC Section 6694, which is understatement of tax liabilities, and engaging in activities subject to penalty under 6695, including under 6695G, failing to perform proper due diligence tests for returns subject to the Earned Income Tax Credit and similar options. 13 years later, in 2024, the government alleged that she was at it again, continuing violations. This time they focused on inappropriate head of household claims and the fact that the Social Security numbers that she was listing for the qualified persons that qualified somebody for head of household status weren't theirs. They weren't anybody's, right? They were just kind of there. So the court held an evidentiary hearing this year, and they found Martha in contempt of court. So now let's talk about basically the analysis of why was Martha in trouble, in case you have trouble understanding this. The district court, has its order, so it can enforce its order through civil contempt proceedings. Civil contempt does not require willfulness, it simply requires a violation. Now, to get the civil contempt action going, the government had the burden of showing by clear and convincing evidence a violation of a specific court order. What had Martha violated? In this case, they're invoking 6695 that penalized preparers for due diligence. In this case, the head of household status. When you have a taxpayer who has a return and they're claiming head of household status, as we know, you have to go through certain due diligence steps to, verify the eligibility or at least get information that it suggests to you that they're eligible. Now, these requirements mandate that the preparer, Martha, must not know or have reason to know that the information used for the head of household eligibility on the return is incorrect, and that Martha must make reasonable inquiries if information appears incorrect, inconsistent, or incomplete. As you might guess, randomly generated Social Security number, when she didn't have the real one, that seems to violate both of those, right? She knew it was incorrect. Well, I guess in theory, she might have accidentally randomly generated the correct ID number for the kid, but it was wildly unlikely. And secondly, she needs to make inquiries. If she hadn't been provided that information, she needed to get it. Now, she admitted to purposely using a random 9-digit number as a workaround for her software because, you'll believe it, her software would not let her submit a return for head of household status if there wasn't a qualifying person with a Social Security number on the return. And dang it, am I really supposed to call everybody and get a Social Security number for that? Is that what we have to do? Yeah, that is what we have to do. You really need that information. This is kind of obvious. Now, of course, she said, well, it's a workaround. My software was glitching. This was not a software glitch, right? The court found this explanation, they were kind, they used the term insufficient, right? They indicated that knowingly providing incorrect Social Security numbers without reasonable inquiries is by itself a violation of due diligence under 6695, which, by the way, is what she was ordered not to violate back in 2011. So she is in direct violation of the court order. Now, and as we said, you have to show she understood or willfully knew. When the court tells you not to violate that section, it's up to you to make sure you understand that section. That's key, and understand your responsibilities. The fact that she might not have ever bothered to read the regulations or bothered to read anything else related to this would not get her off the hook. So the court held her in civil contempt for violating limited injunction by failing due diligence under 6695. Now, the IRS asked for a $228,575 sanction. That would have been total disgorgement, right, of all of her head of household claims, all she'd benefited from filing those returns. The court found that was inappropriate because the government failed to prove that, these taxpayers, these were all claims that were invalid. They didn't offer clear and convincing evidence that had Martha actually done what she was supposed to do and gotten Social Security numbers, these kids may have valid Social Security numbers. These people may be validly head of household. They hadn't proven that they weren't head of household. But instead, the court imposed a $20,000 sanction on Martha in order to convince her it'd be really helpful to comply in the future, because they did note that she had similarly had due diligence failures. The IRS had previously fined her $6,000 in 2016 and $4,080 for 2018, and that obviously didn't stop her from doing this. So the court said, we need to go back and come back with something a bit stronger. So the court said, look, the maximum penalty under 6695 was $25,000. Our $20,000 is well within that range. It's not the max, but it is up there. And bottom line, she clearly needs an incentive to follow the law. So she was ordered to pay that sanction within 60 days. So a couple of takeaways. Obviously, ignoring court orders is a problem, and anybody subjected to one needs to make sure they follow them. Again, does not need to be willful. Once the court gives you an order, you need to understand it. And if that order says don't violate this particular IRC code section, you need to understand what that section requires. Martha at best did nothing, or certainly didn't understand what it required, and that's if we want to be kind to her, or just decided that, what? I don't think I'm going to be able to process returns and make the money. And maybe I do have some fraudulent ones in here. So I'm just not going to even go down that route. I'm going to just go ahead and make these up so I can keep getting the fees. That's the less, shall we say, sympathetic way to read it. And there was a non-negotiable issue on due diligence. If you knowingly provide incorrect or incomplete information, even if you think it's for your flaws in your software or a workaround, that constitutes due diligence violation. 6695 does not allow you to work around this problem. And you should understand that it was, even if there was a software problem, providing a fraudulent ID number violates 6695. If that's what you have to do to work around the problem, you need to find another solution. Change software vendors if need be, but that's not going to be your solution. Obviously, having previously been penalized, we had the 2011 case, we took her to court. Following that, she kind of stayed in compliance, for 5 years. And then suddenly she violated, and 2 years after that, she violated again. And that history is going to come back to haunt you. That's why the court decided to throw the book at her, and why the IRS got tired of using the civil penalty rules under 6695 and simply said, well, we're just going to go and ask for contempt to get all of this stuff kicked back out. Okay. Now, the burden of proof on government when they go to court on this, why they're using this as a 6695, is high. That's why 6695 is an easier route for them and what they apparently used in the interim years. But the fact is that since she wasn't paying attention, they went there. And once they establish that you violate a court order, now the preparer, not the taxpayer, get used to saying taxpayer, the preparer has got to justify why they didn't follow it. So bottom line, hopefully you all know that you need to take steps to ensure accuracy. You do have a due diligence requirements in preparing your return, especially if you are a Circular 230, licensee. There is a due diligence if you're a CPA. There's a due diligence requirements under the SSTSs. You're an EA under Circular 230, there's due diligence requirement. right? Basically, we're there. And you got to make reasonable inquiries. As I tell people when I teach lectures or give lectures on ethics and regulatory compliance for CPAs, that basically you're in charge of the law. While the client gives you information, and you normally can accept what the client tells you unless you have reason to believe it's an error, you're responsible for understanding what the law requires, including what it requires for information on the return, and get that from the client. And again, even when you get it from the client, if you have reason to believe that what the client gave you is wrong, and that is you can't play ostrich and just bury your head in the sand, you need to then make follow-up. That's your due diligence. Obviously, in this case, when you don't do that, not only could you face IRS action in a case like this, but that's also how cases go upside down when we talk about liability cases for civil liabilities to clients or others off a tax return. So, yeah, be careful there. You got to make sure that because again, if it doesn't comply with the law, it failed to include information required to be disclosed, required to be provided, that's on you. If the information is wrong, but you had no reason to know it was wrong, that's on the client. So keep that straight. Next up, a very creative reading of the credit for electric vehicles prior to the Inflation Reduction Act under Section 30D. We're going to talk about the placed in service rule and what it means. This is the case of Moon versus Commissioner. It is a published tax court decision, 165 TC number 4. And it was interesting because it's the shortest published decision I remember reading in a long time. The actual post on the tax court's website was 4 pages, and it was really more like 3.5 page opinion. So yeah, it wasn't much that was there. And they released this on September 10th. But it is a published reviewed petition. So we're going to be there. Take a look at that. So what we're looking at here is what is the placed in service rule under the prior version of 30D. Now, one interesting fact we're going to point out at the end of this is in the Inflation Reduction Act, they actually modified 30D to specifically get rid of this potential interpretation. But it's just kind of interesting, about that and what's there, but it did get added. So apparently somebody was aware that as originally written, there was at least an argument, not a very good one, as we'll discover, but there was at least an argument, at least not very good in the eyes of the tax court, that placed in service was a year-by-year thing that you would run. Because we're going to discover and it appears, to be honest, the taxpayers in this case essentially got their Chevy Bolt totally paid for and got money in pocket, because we're going to find the year in front of the court was not the only year they did this, but it appears to be the only year that the IRS was able to take to court. So we're going to be here. So the question is, when is a new vehicle considered placed in service? And the real question is, do we test, in essence, do we consider every year you use it as a year you placed it in service, or is placed in service a one-time event? So the timing, eligibility, the credit are sort of key, because the catch is, if it's in fact something we test every year, did you use the car this year, place it in service for the year, then that's $7,500 per year that you get a credit. While if it's a one-time event, it's only a single $75 credit you get a year that you actually acquire the car and, quote, place it in service. So we'll get there. So in 2013, the Moons purchased a new Chevrolet Volt, which was a plug-in electric vehicle. We know that it was one of the least expensive vehicles that qualified for the credit. They claimed the maximum $7,500 credit, not only in 2013, but annually from 2013 all the way through 2019. So effectively on 7 straight returns. The 13, 14, 15, 16, 17, 18, 19 returns. So we're talking about 7 times $7,500. Now, as I said, a Chevy Volt was not exactly up there in price with a Tesla. Its price was much more down in the lower end. So we're talking about a Volt that got paid for multiple times over by this $7,500 credit being taken every year by the Moons. Right. Now, the IRS disallowed it on 2019's return, right, asserting a $7,500 deficiency for that year. Saying that, yep, that's it. There's this deficiency on the 2019 return. Interestingly enough, no mention is made about the IRS going after any other year. My guess is the statute had closed on those years. And nobody's arguing that the Moons had fraud. And remember, this is a tax credit, so it's not going to be subject to the, understatement of income, omission of gross income, because that wasn't what they were doing. So it's tough to feel too sorry for the Moons in this case, shall we say. But we'll get there. Their argument was they were entitled to credit for each year the vehicle was placed in service through continuous use. They said, essentially the first time I drive it every year, I place it in service for that year. And since I get the credit for each vehicle placed in service during the year, every year I should get a $75 credit for owning this electric vehicle. How they do that? Language, the straight language from 30D subsection A is what we're going to look at here. That says, and I quote, a new clean vehicle placed in service by the taxpayer during the taxable year. Now, that's the current wording. Previously, it was the electric vehicle, qualified electric vehicle. But essentially, it's still worded the same way. Now, notice, the section itself never defines the term placed in service. How they were reading that section was, as I said, the first time I drive it, every year I own it, I place it in service during that tax year. So therefore, I get the credit every year. Now, the problem is the courts, yes, the courts do look at definitions in the section, that they also look elsewhere. So if there is no internal definition, we saw this concept of what does placed in service mean. So now what the court does is starts looking outside of this section to see if that term is used elsewhere in the code and what that term means in those contexts. And if it's consistently used to have the same meaning in other contexts, then they'll apply that to this definition. So understanding, and this is what gets difficult about the theory of when you're trying to interpret the law, is that statement unambiguous? Because remember, if the law as written provides only one way of reading it, then that's the end of discussion. So is there only one way to read this? And that is, nothing in here says you only get it once, right? And placed in service, a reasonable interpretation of that using standard English would be, well, just means each year, right? I mean, as soon as I use it. Well, the court didn't buy that. The court went back to definitions over the years, and especially all the way back to the previous, or basically still existing, general business credit in Section 38, the old investment tax credit rules under Section 46. Specifically, Regulation 1.46-3D1. That definition said the definition of placed in service, which, by the way, is used all throughout the depreciation. It was used, obviously, in the investment tax credit rules. It's been used consistently, all throughout the code. That said, property is placed in service at the earlier of the year when the period for depreciation with respect to the property begins, or when property is placed in condition or state of readiness and availability for a specifically assigned function. Now, obviously, this vehicle is not being depreciated. But prior precedent confirmed that essentially, therefore, we would say placed in service occurs when the property can be regularly used for its specifically assigned function. That is, it is a one-time test. So as soon as it meets that condition, it has been placed in service. And that is a one-time event, not an event that recurs multiple times that we retest every year. So the court said Section 30D's credit is a one-time credit because placed in service has consistently been used in the code, in other sections, other provisions, to be this one-time initial use test, not something that just looks at did you use it in a year. Okay. Now, upon purchasing that Volt in 2013, they took delivery immediately, so it was ready, available, and used consistently with a specifically assigned function. So it was placed in service in 2013, and that's the only year that counts for being placed in service. Since that's a one-time benefit, it's only allowed for tax year in which vehicle was first placed in service. Notice they didn't put first in front of that, which is, initially. Code doesn't. And since it already claimed the credit in previous years, that exhausted their entitlement. So specifically for 2019, basically they weren't allowed to claim the credit. So for 2019, sorry, we're done. But considering that they still got 6 years, that's essentially 6 years of credits. That's $45,000. And that likely is more than they paid for the Volt. So again, I can't feel too bad for them about that. $45,000. I mean, I don't remember what Chevy Volts were selling for in 2013. But as I recall, the Volt's pricing was not exactly, as I said, it was not like buying that, the EV Porsche. It wasn't one of those six-figure vehicles. So yeah. And what happened, which is now funny, Congress did eventually modify Section 30D in the Inflation Reduction Act. And now it says that the credit is described in subsection A, should only be allowed once with respect to such vehicle. Now, in theory, the court could have read that to mean that Congress, do we take any reading, make any assumption based on that previously it was allowed more than once? Generally, no, the courts won't really do that. But it is interesting that that's now in there. So apparently somebody became aware of this style of reading. And so, they just patched that hole in it. Okay. So bottom line, not surprisingly, certainly the way all of us thought it worked anyway, the clean vehicle credit under 30D, both the one back from before IRA and the IRA version that's going to be ending as of, the end of this month, it is a one-time only benefit looking at your initial placed in service date, not based on every year looking to see if you've now used it this year. So understanding placed in service is a term of art used throughout the code, and at least the tax court decided that it should be considered to mean the one-time placed in service test when Congress, you might argue, inartfully used the term here. They didn't use the term first placed in service. They didn't say it was only a one-time credit. You can argue that they weren't as artful here as they were elsewhere, but the court still concluded that that term has always been used to mean just one time. So you got to, as we say, communicate to clients that subsequent use in later tax years does not qualify despite what their buddy told them. So you can't keep getting the credit. And like we said, new legislation made it very clear. Not that's going to matter after this year, but it's now very clear that, that didn't work. So certainly beginning with at least anything placed in service under the updated IRA rules, that was very clear, a one-time only option. Next up, bad day for the tax advisors, really more promoters, in a particular tax structure that they tried to talk a taxpayer into doing. So this is advisors are found to owe treble damages under state law to taxpayers that got nailed by the IRS for an overstated charitable contribution. This is American Properties Company, GP, which, by the way, was the company that was suing in this case. So there's your plaintiff against the Wealthfront Group, LLC. This is the United States District Court for the Western District of Tennessee. This is case number 2:22CV0239. And this case came down on September the 11th of 2025 is when we got our opinion. Bottom line, there are nasty consequences that occurred in this case, including substantial actual and treble damages for fraudulent or negligent tax advice and appraisal practices, particularly in complex charitable contribution schemes. Now, I'm hoping nobody here is actually promoting such a thing. If you are, definite cautions here. By the way, if you're doing what these people are doing and you didn't realize that this will go way beyond just simply an aggressive tax position, because we'll discover there's some stuff going on in the background the taxpayer wasn't aware of that might have influenced their own decision about whether to be part of this. Okay, because in essence, the parties in question, at least related parties, were finding another way to extract value, shall we say, from advising this client. So, yeah, it's kind of interesting. So let's talk about the case. In this case, American Properties, the plaintiff, they were looking to sell a piece of property that they owned for $4 million, $3.995 million. Now, Wealthfront Group, the defendant, the parties they're suing, the advisors, well, they thought they were advisors, they proposed a scheme. They said you can obtain a qualified high qualified appraisal. They're saying that we can get you an appraisal on this property that says it's worth $5.4 million. You can then sell the property to a charity for less, basically $2.16 million, and you'll claim a large tax deduction that will actually give you the effect of as if you received the total $4 million. Without having to pay that huge gain, you get this big deduction, right? And we don't have to pay tax on gains, and so it works great. Now, Wealthfront earned a $62,403 commission off doing this. They advised them to do it. They got a commission. The taxpayer apparently knew about that part of it. So what they did, they introduced another defendant called the Tax Appraisal Group, TAG. Now, this is managed by another defendant, Linda Skull, to provide the appraisal. It was grossly undercapitalized per the court, and its earnings were devoted to Linda. The appraisal provided by the default, basically Tax Appraisal Group, TAG, was not a qualified appraisal. The court found there were a lot, basically the IRS found a lot of problems here, right, with it. She wasn't a qualified appraiser. It was all kinds of problems with her. She didn't really do this, didn't have the expertise, all kinds of problems. It was not a qualified appraisal. However, the taxpayer didn't know that. They relied on the representations and sold the property for charity and claimed a $2.6 million tax deduction on the bargain sale. Right. What they didn't know was on the same day that sale took place to the charity, an alter ego of Wealthfront, that's the term the court used, but basically another party stepped in and bought the property for $2.6 million. Now remember, that is one heck of a bargain purchase, right? So they got a nice bargain purchase. They got a big discount on this, on a property that presumably was worth $4 million. So in essence, as I said, there was another way to extract value from this transaction besides that $62,000 fee, the commission. Commission was a known. This particular walking away with well over $1 million of equity in the property, excess, basically additional value in the property, prior to, immediately after the transaction, that was not disclosed to the taxpayer. And of course, that undermined the appraised value. If it was truly worth, well over $5 million, nearly $6 million, why in the world did the charity sell it immediately for only 2.6? If you're not aware, the best evidence of the value of a piece of property would be a true sale that took place between unrelated parties. Now, whether the charity, how much the charity knew about this, what they were involved with, if they were aware, if they were also scammed by this, saying, hey, we'll buy it from you for this, because the charity's probably like, what are we going to do with this piece of property? Say, we can take care of that. We'll go ahead and take it off your hands. We'll give you a nice, tidy little, profit off of it. You're only paying 2.1. We're going to go ahead and pay you 2.65. So, there's $550,000. So you pocket that. We're good, you're good, all's well. But the problem was, it set the value. So the IRS determined the appraisal was not qualified. They said the property's fair market value was, guess what, $2.65 million. What Wealthfront paid for it, Wealthfront established a sale. Willing buyer, willing seller sale. And part of the reason why the service can go with that is because, they're part of the transaction. Taxpayer may not have known it, but that was all part of the deal. The deduction was therefore reduced to $490,000. And the taxpayer owed $571,765 in taxes and penalties. The taxpayer sued Wealthfront, Tag, and Skoll. The defendants failed to appear at trial. It would have been a tough defense, I have to admit. So that resulted in a default judgment against them. Right? They failed to show up. They didn't try to defend. That's never a great legal strategy, I would guess. I would think most attorneys would say, but maybe you thought, what the heck? We're just going to get the book thrown at us anyway. So, in any event, default judgment comes out against them. So it's going to go forward at that point. Because that upon a default, well-pleaded allegations of liability are admitted, but damages must still be proven. The court calculated actual damages based on the IRS notice of final partial adjustment, including underpayments, penalties, and accrued interest, totaled $1.751 million. $1.751,824, actually. They also found that there were tort claims for fraud, negligent misrepresentation, and just simple negligence. They were found liable for misrepresenting the property value, failing to provide a qualified appraisal that they had told the taxpayers they would provide. And that led to the loss that the taxpayer incurred, this huge bill from the IRS. The Tennessee Consumer Protection Act, that covers this case. Defendants were liable for willfully and knowingly making false material representations. This is a state-level RICO statute. It allows for treble damages. So basically, now we know their damages are $1.75 million. Triple them. Okay. So it turns out the plaintiff, assuming they can collect, which is always a bigger question in a case like this, they might not be so bad off. They also extended the liability. Linda Skoll was held jointly liable with Tag. Now, Tag, remember, was the entity that supposedly contracted with and provided the appraisal. But they're saying that it was simply just her alter ego. She didn't basically respect the entity. It served no real purpose except to, allow her to try to escape liability. So the court said, okay, Melinda, you're going to learn about piercing the veil. You just got it pierced. They're also found a civil conspiracy. They acted in concert for the scheme. So each one of them is jointly and severally liable for all damages. American Properties can collect the entire award from any one of them. Or they can go after all of them. Right? They still can only collect the total triple damage, but they can go after everybody for this. So if anybody here has property, things they can seize, American Properties may now own that, when they move. The court concluded that Wealthfront, Tag, and Skoll are jointly severally liable for the plaintiff's claims. That final judgment included $1,800,000 $751, $824 in treble in actual damages, and then $5,255,472 in treble damages. That's 3 times the actual damages to punish them under this. So the total damages awarded, not yet including attorney's fees, were over $7 million. Okay, so they didn't necessarily walk away, if this is collectible. The one problem with an award like this is don't assume American Properties is going to get the $7 million. I suspect they believe they can get a good chunk of it because otherwise litigating this would have been a waste of time. And I'm sure their counsel does not work for zero. So presumably they know that there's something there, at least of value, maybe not $7 million, and that'd be the obvious move, but there's at least enough assets they believe they can at least make themselves better off by enough to justify going to court. Now, the attorney's fees were not awarded at the time due to lack of supporting documentation, but if American Properties wants to, they can file a separate motion with additional evidence to be granted attorney's fees. Again, whether they go ahead and do that is probably largely going to depend upon whether they believe there's any chance whatsoever they're getting the $7 million to begin with. Because obviously, if you're only going to get $2 million, regardless of how many damages were awarded, may not make a difference. So, again, we'll see. Now, why should any of us care about this, assuming we're not people putting together this kind of a deal and then on the side buying the property off the charity after we got it sold to the charity at a low cost, buying it below market from the charity? Assuming we're not doing things like that to our clients, and hopefully you're not, you're going to get beat up in court if you're doing that. Just bottom line. You need to be very, very careful with charitable contribution schemes. Due diligence is paramount, and that's true if you are the party who has a client who's approached by somebody like this. Remember, in many cases, they're telling the client exactly what they want to hear. And they're probably going to say, well, your CPA or your EA doesn't know about this, or they just work for the government. I mean, there's variations of what they do. But if they're going down the route of saying, that they just don't understand this, a lot of times they're going to give you some sort of document showing why this supposedly works in this case. And they're going to hopefully just intimidate you. You're not going to want to say that, no, this doesn't work. I'm going to say, show me why it works. And then I'm going to point out the very real problem is, well, it's got to be a qualified appraisal. So what exactly is TAG who's going to do it? Because if you remember an earlier case we discussed this year involving that donation of a painting to the Metropolitan Museum of Art, the qualified appraisal can't be an entity. It's got to be an individual. Who's the individual? And assuming they tell me it's Linda, which they really would because Linda was that thing, then what's her qualifications? Does she meet all the criteria? You got to look at that. Like it or not, you need to be looking into this stuff, whether you like it. Advising on or facilitating a transaction, that's also a bit of a problem. Even if you're just involved in facilitating, you never know if somebody else, do we really know at this point, I'm not sure the case told us, if Linda was aware of the other part of the transaction. She was aware of parts of it, but you could find yourself tied up in a situation like this if, let's say you were getting the commission, but little did you know other parties in the transaction were basically putting up related entities you didn't know about who would go back in and buy the property at a discount after setting this up. You suddenly could have problems. And you really do need to be aware of this. Again, especially if you get yanked into the scheme in some way, shape, or form, you can be essentially jointly and severally liable. Courts can find that. And veil piercing can take case, if corporate formalities are disregarded, or frankly, the case just smells. Judges will work and claim a veil piercing if everything smells bad, they'll go after it. So as an advisor, assuming that you are not doing this, but your client's approached by it, you really need to tell the client they need to investigate these things in detail. Understand the relationship of all the parties, right? And if a promoter suggests an inflated appraisal, immediately point out all the cases we've discussed where those appraisals have been shot down. Be careful. That's an area the IRS is looking at right now, so look into it. If it sounds too good to be true, it probably is. I know the client's been told, and I would flat out tell the client, if you don't have any confidence in me as a CPA, or you think I'd be so dishonest that I'd be, quote, on the take from the government, and I'd be working for the government without telling you, then I think you need to find a new advisor. But if you think working for the government means that I'm going to tell you if something's simply not allowed in my judgment of the law, I'm going to tell you, and I will refuse to sign a return if I don't see a reasonable basis. But a reasonable basis means I just have to conclude there's at least a 1 in 4 chance that this could succeed on the merits. So that's not really working for the government. Are you okay with doing this if there's only a 1 in 4 chance you're going to succeed? And if you lose, you could be nailed just like this? Are you okay with that? Because if you are, with disclosure, I can sign the return. And I'm not going to tell the government you did it. We are going to have disclosure, which you're going to do to try to get out of penalties. So I'm going to suggest that to you, but I'm going to try to give you an independent evaluation because that's what I do. I give you an independent evaluation of legalities. Ultimately, it is your choice on what to do. I've walked through this with clients multiple times. I've walked through it with clients this past week on situations where there was an issue and saying, look, I think this, if push came to shove and the IRS came in, I think this would lose, but I think there is enough of an argument in support that I could sign the return with disclosure. But you have to understand, if this goes wrong, the disclosure would protect you from the penalties, almost certainly the 20% penalties. But what it won't do is protect you from having to pay the tax, having to pay interest, and having to pay for representation in an exam. So again, if you're okay, I can do the return. If you're not okay, I can't. If you don't, as I find most clients don't want to do things, if they believe on exam they would end up owing tax, or there's a possibility or probability they'd owe tax, they generally don't want to do the transaction, then we just don't do it. But my job is to help you recognize when you're in that position that you're exposed, that if an exam came up, there's a greater than 50% chance you would lose on this position. That's my job. That's what you hire me for. But I can sign a return all the way down to 25%. So understand, if you really want to go ahead, only when you get down into the, oh, come on, you got to be kidding, levels of the position on the return, am I going to turn around and say, sorry, out of here. Actually, I might do it before then, but that's a whole nother issue. Next up, this is actual development this week, the second reported case, but not trying to get your vote paid for by the government, literally. In this case, we're going to talk about W-2 wages and the qualified business income deduction under Section 280 Cap E. That is the provision that for the state legal marijuana dispensaries, the cannabis businesses, in those cases, how does it work, the QBI deduction? And specifically, if it applies, and the IRS concedes that it applies in this case, they don't challenge that, but if it does apply, how do we determine the W-2 wage limitation? Because remember, 280 Cap E is going to disallow a lot of deductions, including especially for a retailer. So dispensary would be almost all of the wages paid in the company. You've got to be in production because you got to get wages into inventory in order to get a deduction under 280 Cap E. So this is a case of Savage versus Commissioner. Actually, there were two taxpayers, so there's two cases, but they're really the same decision. They're both part of it. So this case 165 TC number 5. Again, decision released on September the 11th. The key issue is whether W-2 wages that are non-deductible because of 280 Cap E, business that is trafficking in state legal cannabis that is on the wrong schedule on the federal return, on federal law, therefore is illegal at the federal level, can those disallowed deductions, which are big, can that disallowed W-2 wages still be included as W-2 wages in calculating the qualified business income deduction under 199 Cap A? Remember, assuming their taxable income, the individual's taxable income is above the the threshold amount, and especially above the threshold amount plus whether you're married or if you're married filing joint under law for this year, it's $100,000 in excess threshold amount. For next year, there will be 150. And if you're single, head of household, etc., it'd be 50,000 above for 25, 75 for next year. But you get up that high, you can only get QBI is limited to no more than 50% of the W-2 wages that are applicable to the qualified trade or business. Therefore, if you have no W-2 wages, then you have no 199 Cap A deduction. If you have only minimal W-2 wages, right? Let's say you do have some production work, so some things go into inventory, but you don't have W-2 wages, but the other W-2 wages for, the sales area, the retail area, those are non-deductible. You have very limited deduction. So the two petitioners here are Ayla Savage and Patricia Torres. They were shareholders in a couple of S corporations, or actually a few of them. Two of their S corporations sold cannabis. That subjected them to deduction limitations under Section 280 Cap E. So they have two S corporations. They have other things going on, but they have two S corporations that sell cannabis. In 2018 and 2019, they claimed the qualified business income deduction, so the first 2 years of TCJ, under Section 199 Cap A. In calculating that deduction, because they were over the threshold amount, I think it's actually plus phase out, because that's where it would matter in large extent. They treated all W-2 wages paid by the cannabis S corporation as includable, regardless of where those amounts were deductible. So in essence, let's take a simple case of a dispensary that has no wages that could go into, that would be deductible. Well, let's say they paid $100,000 in wages. Do we count that 50% of the wages, $50,000, as our cap on the 199 Cap A? Or do we have to take out all the wages we couldn't deduct? Which now would be all of them, and our limitation is 0. Now, it was not true for Ms. Savage and Ms. Torres that they were 0. There were some allowed wages in both cases. But it's way lower than what they had, than what they were claiming or what they were paying out. So, and everybody, IRS and the taxpayers, all stipulated a significant portion of these W-2 wages were non-deductible due to Section 280E. And the only real question between the IRS and taxpayer is simple: whether total W-2 wages or deductible W-2 wages is what we need to multiply by 50% in order to get our 199 Cap A limitation. Taxpayers are saying the total wages we paid, it doesn't matter if we can deduct them or not. The IRS said, no, because most of these wages are disallowed under 280 Cap E. Let's say we have 100,000 wages and 90,000 are non-deductible. You got to ignore the 90 and only use the 10 and 50% of that, so 5,000 for your maximum 199 Cap A deduction. That's the only question that this case needs to decide. It's a nice, simple, straight-up law case. Which one's the K? So, now this did result in a split decision, but there's only a single judge on the dissenting side. So the vast majority of the judges on the tax court signed on to this version of the opinion. So the majority began with the plain language of 199 Cap A-B4, which defines W-2 wages by reference to the amounts reported in the Form W-2. By reading that, you'd go, hey, easy. All these wages are on the W-2s. So therefore, they count, right? No, keep reading. 199 Cap A B4B states that W-2 wages shall not include any amount which is not properly allocable to qualified business income purposes of Section C1. Properly allocable means an amount that fits appropriately or correctly, permissibly, with something else. And qualified business income, as defined under 199 Cap A C1, is the net amount of qualified items of income, gain, deduction, or loss. Qualified items under 199 Cap A, I love it, we go through this deep now, C3A must be included or allowed in determining taxable income for the year. By taking those, they're saying it has to be included in QBI, and the disallowed wages are not included. Therefore, wages are qualified items only to the extent they are allowed in determining taxable income. Wages not allowed in determining taxable income cannot be part of QBI. Now, I will note that that reading is interesting because it would suggest that any wages in inventory would seem to be not allowed. And that wouldn't be a cannabis business. Any wages in inventory would only be allowed once you sold the product in question. So that'd be my question about this decision. Is that true? Because again, if part of my labor, I build, I don't care, I make furniture. So labor I'm paying to my employees ends up in inventory, furniture inventory. Do I have to take that wages in inventory? So like add the wages that were in beginning inventory, subtract the wages that were in ending inventory, and come up with an adjusted wages number? Because that seems to be the logic the decision is following here, even though they're only looking at the cannabis business. That'd be a question I'd ask, because that would be a concern. Don't know if the IRS will go there. I suspect they won't. But I would suspect you could. So we have to see it. The court rejected, the S corporation owners' arguments. They emphasized the need to give effect to every clause of the statute, and they deferred to Congress on this policy. So therefore, wages paid by the cannabis S corporations were disallowed under 280E. They're deemed non-deductible wages because they were not allowed in determining taxable income for taxable year. They cannot be considered qualified items of income, gain, deduction, or loss. Consequently, these amounts could not be part of qualified business income. Non-deductible wages are not properly allocable, cannot be included in determination of W-2 wages for 199 Cap A deduction. That affirmed the IRS position, right? It resulted in significant tax deficiencies for these two shareholders for 2018, 2019, and I suspect it wasn't good news for their returns for 2020 and later, assuming they were still running the dispensaries or whatever their cannabis business was at that point. So, key takeaway here. Any business subject to 280 Cap E, state legal cannabis for the most part, only W-2 wages deductible after application of 280 Cap E can be included in W-2 wages for the 199 Cap A QBI deduction. This is going to greatly limit the QBI deduction's benefits for cannabis businesses because a large portion, or maybe even all their wages, will be non-deductible. So you got to carefully differentiate between total W-2 wages and deductible W-2 wages when advising clients in 280 Cap E affected industries regarding their 199 Cap A calculations. And this is the plain language theory is what the court said. Now, the dissenting judge essentially disagreed and found that this was improper and that it thwarted the whole purpose of the wage limitation was to encourage hiring. And this seems to discourage it at best. It certainly doesn't give a benefit. But again, with only a single judge that went out on a dissent, the tax court's pretty unified here. The question will really be, where do they take this up on appeal, and does an appellate court agree with that? That could be probably the more significant. Well, I guess it's significant right now because since the tax court said this, and it's a published decision, right now, if you have a client that's facing this on exam, and you get, and basically They say, sorry, look at this case. We're disallowing most of your QBI deduction or maybe all of it. Your client's not realistically going to want to go to tax court right now. We know the answer the tax court's going to give. So the answer would be like if I got a client here in Phoenix with that problem, they'll say, okay, right now we know the tax court will say no. So are you willing to go to the Ninth Circuit Court of Appeals? Because that's really our only option. We would have to go to San Francisco, where the Ninth Circuit sits. Basically we'd have to go up to San Francisco, or you'd have to take counsel with you up to San Francisco and try the case there, because you're going to lose at tax court. Got to go up that far. Or maybe you need to consider paying the assessed tax and then going to either U.S. District Court here in Arizona, which will still route through the Ninth Circuit. And so if you win, it'll go there anyway, or going to the Court of Claims. And that's really a question that they, with their counsel, have to discover. But right now, a tax court petition, unless this gets reversed on appeal and gets reversed, I didn't check to see where this would go on appeal. But, if for my clients, unless the Ninth Circuit was the party that reversed it, it's a real uphill fight. So just be aware of that. So you have any clients in the cannabis business, you've been taking 199 Cap A based upon the entire wages on the W-2, you got to say that now we probably need to either back off that, certainly disclose it if we're doing the whole thing, and tell them about, it's bad news. If the IRS comes in and disallows this, you try to go to tax court on this, you're going to lose as things stands right now, unless unless Court of Appeals overturns them. So then you need to be talking with an attorney about paying the tax and then suing for a refund and going down that path. So yeah, it's a problem. So as I said, as we go. Finally, we're going to look at a trust fund recovery penalty case and a little bit about refund claim timeliness. So that's really kind of a very small detail here. Take a look at Richter versus United States. Don't know how I pronounce Roger's name. It was a case for United States Court of Federal Claims, case number 22-1690, and the opinion came down on September 10th. Now, this case is going to look at definition of a responsible person and willfulness under Section 6672, the Trust Fund Recovery Penalty. And also, though, as I said, not really something I think is going to be crucial for us to understand here, except just kind of odd the timing got screwed up. What is the timeliness of a tax refund claim under 6511? So let's take a look at the trust fund liabilities, because this is something that your clients, especially if you have any clients who serve as CFOs, right, controllers, CEOs, etc., they're officers in business, especially ones they don't own, that they need to understand that this is something they have to be aware of when things go south. So in this case, Mr. Richter was president and an indirect 5% shareholder of MECO Environmental LLC and its subsidiary ICIPT. Now, Roger oversaw ICIPT's day-to-day operations and was a co-signer of 2 of that subsidiary's checking accounts, involved in ensuring vendor payments. Now, he said he did not have financial oversight in that case. By early 2010, both the parent and the sub had severe financial problems, and both had failed to pay federal payroll taxes, trust fund taxes. Remember, trust fund taxes are taxes you have withheld from your employees that are due to the federal government. So normally we're talking about federal income taxes withheld and the employee portion of FICA. Those are considered the employee's funds that you now hold for transmission to the federal government. They are not your funds, and that's why they're considered trust funds. I will warn you that most states have a similar rule for state withholding. We're not going to talk about that here. And also many states have a similar rule for sales taxes collected, right? You're collecting on behalf of the state from your customer. Therefore, that could also be. So there are various ways to get into trust fund trouble. Today, we're talking about the payroll tax federal rule only, because that's what's in front of this court. By early 2010, as we said, they're in danger. They failed to pay their trust fund taxes for all 4 quarters of 2010 and the first quarter of 2011. Now, Richter filed a complaint seeking a refund of $411.23 for overpaid income taxes. Right? In that case, overpaid taxes. The government counterclaimed said he was liable for $212,454.31 in unpaid trust fund taxes under 6672, asserting he was a responsible person who had willfully failed to pay. Now, the government sought to dismiss Mr. Richter's refund claim for the first quarter of 2020 as being filed untimely. Now, bottom line, employers have to withhold income and FICA taxes from wages and remit them to the IRS. We understand that. 6672 imposes a penalty equal to the unremitted amount any person required to collect, truthfully account for, and pay over such taxes. And remember, it's not just, in this case, they had collected them. But if you know you should be collecting taxes, and people get in trouble, this is where payroll taxes, where when they go back in and they do an exam and look at people who you've treated as an independent contractor, they later determine are employees. They can go after you under this for failing to withhold the federal income taxes, and that can be a trust fund problem. So be aware of it. We have issues there. Now, for 6672 to apply to somebody, 2 things must be true. That party must be a responsible person. That's a defined term. Somebody under a duty to collect, account for, and pay taxes. And that responsible person must have willfully failed to perform this duty. The taxpayer bears the burden of proving by a preponderance of evidence that at least one of those elements is not met. The IRS basically the United States here, our government, is moving for basically summary judgment that Mr. Richter is a responsible person and that he willfully failed to pay over the taxes. Let's talk about responsible person first. Responsible person status for a person depends on their power to control decision-making process by which the employer corporation allocates funds to other creditors in preference to its tax obligations. The test is one of substance, not form. Do you have the power regardless of what the paperwork might say? Now, things that indicate you are a responsible person, you have the power: check signing authority, management of the corporate, basically fiscal management, any ability to decide who to pay or not to pay, and control over payroll. The government, in moving for summary judgment, pointed to Richter's titles, the fact he could sign on bank accounts, and his ability to direct who was paid. Now, Richter said his authority was limited. He was only a co-signer and not an originator of payments. And any large payment required authorization from others, from Jim Cutler, from Patrick Garrett, or from the CFO, Mr. Adams. Now, crucially, dual signatures were required, and Adams, the CFO, testified that he needed Jim Cutler's approval to countersign any check that was originated by Richter. So, Adams, before he would sign, he would get Jim Cutler's approval. Higher up. The court found that was a genuine dispute of material fact regarding his effective power to direct company funds. The court said this one we have to go into court of law. This is too early. Because again, when you move for summary judgment, the court's going to look at all the facts so far entered, all the things that have been brought forward. They're going to assume what's been done to date is true. And they're going to say, okay, all of that's true. Even if I take all this as being 100% correct, would that still be insufficient for me to say, Mr. Richter, you're not a responsible person? And they said, sorry. If I assume all of this, if I assume everything he's saying is going to prove is true, then he wouldn't be a responsible person. I'm not saying he will be able to do it, but I am saying that government, it's not as a matter of law under the facts as parties so far have ever admitted, right? If I just take his facts and look at the law in the most favorable light versus his facts to him, I wouldn't hold him as a responsible party. So we got to go to trial. By the way, the converse is true too. I also am not saying that basically everything that's been agreed to so far means he's not. We just have to go to trial. Willfulness, though, is the second issue, which the court did look at here. Remember, if he's not a responsible person, then he doesn't know it. But if he is, are his actions willful now? Willfulness for 6072 does not mean what you might think it does. It requires a voluntary, intentional, and conscious decision not to collect and remit taxes. It does not require bad faith. Just fundamentally, if he's a responsible party, he could have ordered them paid. The question becomes, if he could have done it and the possibility existed to pay some or all of them, and he failed to exercise that, that's also considered willful. It can be shown by a deliberate choice to pay other creditors or a reckless disregard of the risk that taxes might not be remitted. So there are two ways into this. First, if you decided to pay other creditors, knowing there are payroll taxes out there that are unpaid, and you decide to let other creditors be paid, that's a willful step. Or you recklessly disregard. That is just, play ostrich. Don't ask, don't tell doesn't work here, okay? Just simply not asking and, being woefully ignorant won't work for you. Once you become aware that there's a problem, and Mr. Richter was aware that there had been a failure to pay over the payroll taxes, you're not allowed to just ignore the fact that that might happen again. You kind of got to follow up now. Now, a big problem we got is Mr. Richter failed to respond to the government's willfulness arguments in his briefs or oral arguments. Now, to say that's not as bad as not showing up, but it's pretty close. So if you don't respond to their arguments, they're going to be granted as conceded. So they're waived. And if we waive, basically, so if we concede all the government's arguments, then essentially, yeah, your actions are willful. Right? They granted summary judgment on that alone. But the court said, even without the waiver, the undisputed facts clearly demonstrated that Mr. Richter was aware of liabilities and he was aware that other creditors being paid in preference to the IRS. That evidence included multiple emails from the CFO, Mr. Adams, and other administrative staff, specifically warning Richter of unpaid payroll taxes and even allocating bridge loan funds for past due payroll taxes. So he was aware there was a problem. He signed multiple checks to other creditors after becoming aware of tax deficiency. And remember, the mere fact that he maybe couldn't sign him a loan to pay the taxes did not get around the fact that he still signed to pay he signed to pay other creditors. In essence, that's a problem. Now, what about his timely filing? Well, that's a foot fault problem here. 6511A requires a claim for refund to be filed within 2 years from the time the tax was paid. This is jurisdictional. The government demonstrated that Mr. Richter made his final payment for the first quarter of 2010 on June 18, 2018. That means a refund claim had to be filed by June 18th of 2020. He filed his complaint in 2021, well beyond the statutory deadline. Similarly, the willfulness argument, he failed to respond to the government's timeliness argument in his briefs or during oral argument. That resulted in a waiver. Therefore, the court granted the government's motion to dismiss his tax refund claim for the first quarter of 2020 due to lack of subject matter jurisdiction. Okay. So, bottom line, determining who's a responsible person is very, very fact-dependent. Focus on the actual power to direct fund, not just titles. But I would warn anybody, if you're even vaguely concerned, once you know payroll taxes are not paid, your safest route is to resign. If you're anywhere in the accounting function, conceivably. Because they're known to go far and wide looking for a person here. And as I tell a client, you know the company's in huge financial trouble. When they're at the point they're not paying the payroll taxes and they're taking this risk, they're at the point where they are likely not to survive this. If they don't survive, they won't be paid. And if they're not paid, you owe them. Yes, you'll be unemployed. And I realize right today, as things are looking right now, that maybe being unemployed in certain professions would not be a great thing. Could be a problem. But you're still far better off being unemployed in a bad economy than you are being later unemployed after the economy has gotten worse, which often happens. That's what will push them over the edge probably, if the economy gets worse. And suddenly find yourself not only pushed over the edge, but now owing hundreds of thousands of dollars in unpaid payroll taxes plus interest. Willfulness does not require an intent to defraud. You know tax has been unpaid, you know there have been payments to other creditors, or you just ignore, you just intentionally put the blinders on. I don't want to know about this. That's why you normally need to get out. You're not going to be able to continue to function inside the company without causing a problem that will be shown to be willfulness by definition. Obviously, answers to those, when you go to court, it's always useful to respond to arguments. A couple things here, disregard. Refund timelines, don't forget that 2-year statute rule for a refund. You have to file your court case in 2 years of paying the tax, or at the very least have to file an administrative claim for refund within that 2-year period. Remember, an administrative refund claim will stop everything, and then we'll get another 2-year period if the IRS denies your claim. But if you don't file an administrative claim for refund, right, and then you try to go to district court, yeah, we're going to kind of have the issue here of going for it. And key issues to document what's going on. When you're talking about anybody looking for a responsible person, you want to, hopefully, as soon as you become aware that might be an issue, your client should be accumulating as much evidence as they can about what are their actual duties, what are their actual responsibilities, what can they actually do? And document that stuff because you want to make sure that you withdraw out. And sometimes your problem is you're going to inherit a client who's already knee-deep in this, at which point then I almost always say go get legal counsel because these numbers are big. And you need defense, and you need to be willing to go to court. That may be one way to to make the IRS believe maybe we should go after somebody else, but we'll try it. But you need to be looking at that's issues. But like I say, my advice to any controller is the minute the controller, CFO, anybody on the financial side, or even CEOs, once you know the payroll taxes aren't being paid, even if somebody above you supposedly tells you to pay them, or tells you not to pay them, I wouldn't necessarily ignore their statement and pay the taxes anyway, but I wouldn't sign to pay anything else either. And I'd say I got to resign if you push this. Either we're paying those taxes today or you just got my resignation. Take your choice. Because that's it. If I take this step, I become liable for every dollar that's unpaid. I'm not going to take that step. Tough choice, yeah, but sometimes the only choice. So this has been the Current Federal Tax Developments for September 15th, 2025. Current Tax Developments are brought to you by your state society of CPAs. Again, you can email me, Ed Zollers at currentfederaltaxdevelopments.com. Also, I do participate on the Connect sites for Arizona, Idaho, New Jersey, Illinois, Washington, Minnesota. So you can take a look there. If you have questions, I'll try to look at those as question gets posted. Otherwise, Monday, the September 15th, you're listening on September 15th. Remember that this is flow-through deadline day, drop-dead deadline day. Hopefully all of those are now taken care of. Next up are trusts. Trusts and estate calendar year returns, because that's September 30 date. And of course, October 15th is the individuals and the C Corp calendar year dates. All of those neat things coming up as we get into the end of tax season and head our way toward CPE season, right? As everybody tries to cram in all their continuing education courses, normally in the last 2 months of the year. So I may see some of you doing some continuing education stuff during that time frame. But otherwise, we will be back here next week with more current federal tax developments.